on the employer-employee relationship. This presentation will last about 30 minutes, and a recording of the webinar will be available on the Wagner Law Group website very shortly. You can access previous webinars on the website as well. Let me introduce our speaker, David Gabor. David is of counsel with the Wagner Law Group in Boston. Welcome, David.
Thank you, Barbara, and hello, everybody. I promised myself a long time ago not to get nostalgic when doing these kinds of programs, and starting off by doing a remember when program is not something that I ever anticipated doing. However, truth be told, it was not that long ago when the business world and the way we did things was so different. Payphones were commonplace, and most people only had one telephone number. I remember times where I'd be in the office and somebody would get a phone call, and the switchboard would receive the call, and you'd hear, paging Barbara Lewis, call on line 3, and that was how people communicated. Words like spam, surfing, laptop, and connections had very different meanings in those days. And it really wasn't that long ago. Barbara and I were talking before about the IBM Selectric typewriter and how great it was that it can actually go back a space and correct a typo. But you couldn't go back a page before that and correct typos very easily. So enter technology in the workplace. Albert Einstein said, "It has become appallingly obvious that our technology has exceeded our humanity." Think about the fax machine. The fax machine really only came out in the 1980s. In fact, in the movie Back to the Future, Part 2, one of the scenes was a scene where a person got a fax that he was fired, Marty McFly, and it came in on 4 different fax machines. Think about the personal computer. When I was in college, nobody had a personal computer. The idea of having a computer at home was something that nobody even dreamed of. Laptops? Really, it's a very recent invention. The Internet, again, a very recent invention. And smartphones, again, something that's very recent and has had a tremendous impact on how we do business in this day and age. So now it's common to have a computer at most desks in an office. We have an access to the media. If you're a baseball fan and it's, the pennant race and the playoffs are about to begin, you can get your box score right away. Just go on the Internet, go to MSN or ESPN, and you'll get your scores right away. Want to go to a movie this weekend? You can get your movie times on the computer. We can connect our home to the office and our office to the home in a very different way than ever before. And we can access media from the home. In the late 1980s, early 1990s, I was thrilled that I could take a box of discs and bring a law library home to do work at home. I thought it was the greatest thing in the world. Now I just, hit a website and, put in my password and I'm online. We're accessible 24/7. People now expect responses. Clients expect responses on a Saturday or a Sunday. And if you don't give a response right away, they can be disappointed with you. There was an expression we've all heard, don't bring your work home with you. Now it's no longer a saying or an expression. It's become a reality. Basically, it's a revolution. We just don't do things in the business world the way we used to. The concept of 9 to 5 for many people has been blurred. It's now maybe 6 a.m. to 9 or 10 p.m. Expectations that are made of people have changed. Perceptions that we have of what is expected of us has changed. And quite frankly, much of this was not contemplated at the time that employment and wage and hour laws were drafted. An organization called NERA has estimated that the settlements in 2012 for wage and hour cases was $467 million. And over a period of 6 years, the total was $2.8 billion. Now, those numbers scare the heck out of me. I am sure they do the same to you. But let's go a step further. With the impact of technology and whether or not work done before the workday, after the workday, on the weekend, on a vacation, is considered work that is compensable, is a new area that we need to address. So during the program today, we're going to talk about employment at will, the potential rights created by employment contracts, obligations that are flowing from collective bargaining agreements and corporate policies, and strategies that we can take to minimize risk. So let's start by talking about employment at will. Generally speaking, private sector employers who hire people who do not have an employment contract are called at-will employees. At-will employees don't have rights unless it is created by a statute, such as the wage and hour statutes. And some employees at will are entitled to be compensated for overtime work. And one of the things we need to talk about today and get you thinking about after the program is over are potential errors when employees are misclassified. So I can't overemphasize the importance of proper classification. If an employee is not exempt, but they're classified as exempt, meaning that they don't have entitlement to be paid for overtime, the company has a potential risk. It's not just a risk to be paid back what's owed. There are also liquidated damages, potential additional penalties, and counsel fees, and a frustrated and angry workforce. In general terms, an employee who is governed by the Fair Labor Standards Act, there are some employees who are excluded, such as employees who work in, for example, for Amtrak, and they're governed by the Railway Labor Act, are either exempt or not exempt. A non-exempt employee may be entitled to overtime and other additional consideration. And the factors that are considered as to whether or not a person is exempt: number one, they have to make at least $456 per week or $23,600 per year. They need to be paid on a salary basis so that it's not based upon commissions or bonus structure. It's got to be on a salary basis. And they have to perform work which is described in the statute. Basically, we're looking for people in more senior positions in the company, and I'm going to describe that more in the next slide. And one thing that is critical in an analysis of whether a person is exempt or not exempt is oftentimes not determined based upon a job description or an offer letter, but in fact on the actual work performed by the person. So when you do a self-audit, don't just look at the job description. Find out what the employee is actually doing on the job. That will be terrifically important in your analysis. So to be exempt, and let's say we're talking about a person who is a supervisor, and that's the basis for the exemption, they must be supervising at least 2 employees. But the definition of supervise isn't, okay, employee 1, I want you to work on the Hancock matter, and employee number 2, I want you to work on the Miller project. You have to be doing things such as job evaluations, hiring, firing, disciplining, things like that, that level of supervision, not just assigning work. And you have to have a real input in that person's status. So we also need to have people who are in a position of management. So for example, a doctor, a lawyer, an accountant, an engineer, because of the level of the education and the sophistication of the work, they may also be exempt. So let's back up a moment. As I said before, the wage and hour laws were written before this technological revolution, and it was not possible for the government, the legislature specifically, to anticipate these changes in the laws. So now we have novel issues that are arising, and the courts are trying to figure out what to do with them. So the first issue we have is whether or not an employee is entitled to time and a half for overtime. Is the person exempt? Is the person not exempt? If they are entitled to overtime, is what they're doing when we bring the technology into their work life considered compensable work in the office? And then we can also get to the question of how do we control whether or not these people are working? For example, do we know that they're actually doing work in the evening, in the early morning hours, on the weekend? Should we have known that they were doing the work? And what can we do to govern that work? Those are things that we need to talk about, and that's a big focus on the program today. So let's talk about the statutory definition of employee. The Supreme Court has defined an employee as someone to suffer or permit to work. This typically includes the time an employee is required to be on the premises at a location such as a secondary source, or if they're doing work, for example, as a contractor and they're at a construction site, or they are on duty. And typically the workday begins when they start performing the services and ends when they cease that activity. In 2000, I believe, 5, the Supreme Court expanded that to include what they do is integral and indispensable activity for the company. So the problem we run into as a first brush is the application of the concept suffered or permitted to work in this post-technological revolution workplace. Another problem we have is that the courts don't have a bright line definition of how much you need to be doing when you're on your smartphone, checking emails, phone messages, text messages. How much of that you need to do in order for it to be considered a significant period of time. So they have an expression, de minimis, or insignificant periods of time, such as 10 minutes or less, are often treated as non-compensable. But we have the wrinkle from that 2005 case from the court about work that is significant or important in the workplace, and these are issues that the courts have not yet clearly determined. So when we do our own internal analysis, we have to be prepared to address both standards. And by the way, it is not necessary for you to request the employee perform this service. If you knew the employee was performing the service, or you should have known the employee was performing the service, that's good enough. One of the issues that's come up on a couple of cases I have in the office is where a supervisor is sending an email to subordinates on a Sunday, let's say at 5 p.m., or, believe it or not, at 4 a.m. on Monday morning, talking about work that's going to be performed. Well, did the supervisor really need to do that, or could that have been done at 9 o'clock when the normal workday started? You know, we've got to make sure that we're controlling those supervisors. So what happens in wage and hour cases is that there are audits that are conducted by governmental entities on the state or federal level. Claims are brought by employees, and there's potential for class litigation that could be pursued by the employees against the employer. And the issues in these cases are, is a person eligible for overtime? Are they performing services that are more than de minimis? Are the services integral to the business? And what we need to do is we need to be in a position where we can anticipate and address these issues before they arise. A case that's pending in federal court in Illinois involves a person who works for the Chicago Police Department as a sergeant, and this individual received a device called a personal digital assistant, a PDA, also known by other people as a BlackBerry. And he claims that it was made very clear to him he's got to be available 24/7. He works in an organized crime bureau, and he claims that he was expected to be available 24/7 without any additional compensation. He also has pursued a case on behalf of himself and approximately 200 other employees. The employer said, that's all nonsense. We have a written policy where we compensate all of our employees for overtime. And we require that the officers submit time due slips if they believe they're entitled to overtime. So here you have a written policy from the Chicago Police Department says you're paid if you work overtime. Just put your slips in, and you have an individual saying we're expected to be working 24/7 and talking about an unwritten policy. So the city of Chicago makes a motion to dismiss. What does the court do? The court denies Chicago's motion to dismiss. And the reason why they do it is because they were satisfied that Allen alleged he routinely and regularly responded to phone calls, emails, and work orders off the clock as expected by the employer without payment for the excess hours worked. And also, he said that the city did not keep records. That's an important concept. If a person, let's say a person's working as an administrative assistant, and they take some work home with them because they didn't finish something in the office and they bring it home. And they don't tell their boss they're doing work at home. How is the boss going to keep records of that time that's worked? How would the city keep records if, Alan gets an email about a possible sting or is communicating with a fellow sergeant or detective? How is the city expected to do that? Now, after the court denied Chicago's motion to dismiss, the court in January of this year granted a motion for conditional certification of a class lawsuit on behalf of Allen and potentially 200 other people. So this case is a clear indication of the challenge we as employers have going forward. So now we've got a distinction between providing employees with a smartphone or allowing her to use a private smartphone to access company emails. And that's come up in a couple of arguments and in a couple of claims I'm handling at the moment. And in those cases, really, the Department of Labor and the courts don't care so much about who gives the phone as much as what is expected of the employees. And we go back to suffer or permit a person to perform services. One of the arguments I recall hearing in a mediation was, well, the time spent turning on the smartphone is de minimis. Therefore, come on, you just have to turn the phone on, look at your email, say thank you, and close your phone, and that's it. That's de minimis. But however, the other side argued, handling the business matter may be integral to the needs of the company. Good communication was important context, clients, customers, keeping the people happy. And those are the conflicting arguments. So what we want to do is we want to talk about the best steps we as employers can take. And I can't overstate again that this is a law in its infancy. And the courts have not yet established that bright line regarding what constitutes de minimis or a significant amount of time. In fact, there have been arguments that Okay, maybe you spent only 7 minutes on Saturday morning and 8 minutes on Saturday afternoon and another 5 minutes on Saturday night. Each one of those times is less than 10 minutes. But what about in the aggregate? What if we go to add up the time spent on Saturday and now you're at 25 or 30 minutes? Are you entitled to half an hour of overtime? And again, this is something, because it's not clearly defined, it's something that we need to keep our antenna up for and our radar on going forward. So one option is do not issue smartphones to non-exempt employees. If you don't have a business need for employees who are not exempt, and again, back up, make sure you are properly distinguishing between exempt and non-exempt employees. If you don't have a business need for the person to be issued a smartphone, don't issue it. And if they have one, we'll take it back. Also, do not permit the non-exempt employees to access company email remotely. Confirm all this in a policy. And also confirm in your policies that they are not permitted to work remotely on a personal computer or a laptop. So that's one option. You run your company. Do tell your people whether or not they can use a smartphone. Now, there are going to be companies where business necessity dictates that non-exempt employees have a smartphone. And in that case, one thing you can do is you can require that the employees maintain detailed records. They should include the date, the amount of time, and details on work that's done off hours, and submit those records on a regular basis, which will then be maintained by the company and used for paying overtime when appropriate. You put the burden on them clearly to provide you with the information, much like a timesheet, and you pay them based upon that. And of course, please, please, please maintain those records. I picked up a new client with 45 employees. They don't have time records. And it's real difficult to be able to determine whether or not these people are entitled to be paid for the overtime when I don't know when their day started and their day ended, if they took breaks for lunch or things along those lines. There are apps that are available that can track usage on a smartphone. In fact, the Department of Labor has just released an app that tracks the time spent. So some companies can be in a position where you can invest in an app that will track smartphone usage for all of your non-exempt employees. And once again, I stress, please make your policies clear. Now, we're not just talking about smartphones, because we're also talking about use of laptops and PCs and other devices during non-ordinary working hours. Another thing that's happened is it used to be that you get in your car, you drive a half hour, an hour, whatever it takes, and you go to work, you punch in, and you start your day. Now a lot of people are talking on the phone on their way to work, returning calls, and talking to clients, customers, or colleagues about work-related issues. Or maybe they get a call from a supervisor, hey, David, when you get in this morning, I need you to work on the Smith matter. Now all of a sudden, the time they spend commuting can be considered time that is working. So we need to address policies about whether or not people are going to be taking phone calls that are work-related while they're driving to work. And these are things you need to think about, please, prior to updating your policies. One of the other things that I think will help in being able to prepare in advance for potential claims or litigation and put yourself in a much stronger position to defend it is to take an objective and careful look at the culture of your organization. Whether people are really being pressured to work before or after the ordinary workday or on the weekend, or are they perceiving that they are being pressured to do work? Is there a peer pressure saying, You got to be on the computer at 3 in the morning to show how hard you're working because you want to impress your boss. So do a self-assessment on your culture, and you may find, by the way, that some of the supervisors are putting pressure on people, or there's a misunderstanding because of poor communication. In either event, take the time to analyze the expectations of all the employees in the company. And the language in your updated manuals and other policies needs to be clear and unambiguous. One of the things that really helps is to make sure that employees sign a form acknowledging receipt of a policy and maintain that in their records. This way they can't say, oh, I didn't know about this policy, or did it apply to me. And the policy should say, if you work overtime, tell us. And this is what overtime is. You must tell us. If you feel that a supervisor is putting pressure on you, tell us. We do not retaliate. Make us aware. We can fix it. Follow up with employees. Is the policy clear? Do you understand the policy? Are you satisfied with your work? Is anyone pressuring you to work at home? Are you doing any work? And then keep records that you followed up. And audit. Again, as I said before, find out if a supervisor is sending emails off hours to employees. And if so, follow up and take the appropriate steps. And we train. If I'm a judge or an arbitrator and a case comes in front of me and I see that we've got a policy, but the employee is saying something very different, I might do what the judge did in Allen versus City of Chicago and let the case go forward in litigation. But if I see a really good policy and there's training and the employee acknowledges that the employee has been trained and the employee has acknowledged in a form that the policy is being followed, now I have enough that maybe I can dismiss this case. Because now this company is really clearly proactive, and it sounds like the employee has admitted to no entitlement to overtime based upon everything in front of the judge. Now, I mentioned earlier that we were also going to talk about contracts. More often than not, employees with contracts are people who are exempt from overtime. And for purposes of this part of the program, I also want to talk about independent contractors. All right, well, if they're exempt from overtime, why are we talking about them? I think David spent too much time on the internet surfing this morning. Well, there's actually a very good reason why we're doing that. Because oftentimes an employment contract says that a person has a certain amount of time off, whether it's vacations, holidays, weekends, et cetera, et cetera, et cetera. And that person can claim an entitlement to compensation for work performed during that time off. So I think we need to look at the employment contracts. And if it says that you're entitled to 3 weeks vacation a year, but you also are expected to have your smartphone with you and to respond to client emails or contact emails during those 3 weeks, there might be a misunderstanding. And everything will be fine so long as the employer and the employee are getting along. But when a problem arises in that relationship, the employee may turn around and say, you owe me for 15 weeks of vacation or personal time off that I had to work. And if you're talking about a person who's making a significant amount of money, that could be a lot of money the employee is claiming an entitlement to. So I think it's important that we take the time to look at those contracts, anticipate the arguments that an employee could potentially make, and be ready to deal with it. There are also employees who are not exempt from overtime who work under a collective bargaining agreement. And the suggestions made above would apply to these people, but we need to be careful that we're not going to come up with something that's inconsistent with what's spelled out in the collective bargaining agreement. And if there's a disconnect between what's in the CBA and what these people are actually doing, and this potential issue of overtime, then you need to be ready to address it right away, and don't just sit back and wait for something to happen and just hope that there is no grievance or there's no claim brought, because to hope for things to go away is creating a possibility and possibly a probability of a major problem down the road. I'm sorry. Class actions. How do we defeat them? We have a policy. We promulgate. We spread that policy out. We train on that policy. We get signatures from the employees. We show the employee has actual notice of the policy. The employee signed it. And we show that the employee has acknowledged that the employee is not working before or after, is not going on the smartphone, is not checking emails, is not going on the laptop for work-related purposes, is not doing anything that benefits the company on his or own personal time. Sign off on that. And that's your best chance to beat the class action. So what are the tips, things to take away with you from this program? Review the employee classification. Again, it's not just what the job description says, but it's what the employee is actually doing. When you decide about handing out smartphones, think about whether or not there is a business necessity for the distribution of smartphones to people who are not exempt. Determine whether or not there's business necessity to have access from their own private smartphones. And take some time to review the culture of the organization. Understand what is really going on here, not just what's written in the policies or what may be your perception, but what really is happening. Walk the floor, talk to people. Don't be a follower. Well, if another company is doing it, it's okay. Hey, if they're doing it, it's got to be right. Major corporations have been the target of very large wage and hour cases and have had huge settlements. It's not enough to be a follower. Be a leader. Be objective when you review the policies. Have an open mind. Have a person, maybe a third person, look at the policies and ask that person, what do you think? Train. Take the time to let the employees know what the policies are. Have programs. Have Q&A. Make records of your programs. This is all part of documentation. The more you've got records to show you didn't just write a program, but you're educating people on the program, the better off you are. Keep in mind that the technology today can track usage. And by the way, imagine what the technology in 2014 or 2015 is going to be. Everything's growing by leaps and bounds on an annual basis in technology. So it can't be that hard to be able to track the time spent on the smartphone for overtime purposes. Audits. Take the time to see what's going on. Are supervisors sending emails out, 5 o'clock on Friday or 6 a.m. on Monday? Are they creating a problem for your company? And because I talked about the fact that we are in an area of law in its infancy, there is very little well settled about this area of wage and hour law. Keep abreast of the law. What may be good today may not be good tomorrow. Please take the time to keep abreast. And again, this is a fluid area of law, so if you do have questions on the employee classification or whether your policies are adequate in this area, you're more than welcome to reach out to me. And thank you for taking the time to participate in this program today.
Thank you, David, and thank you to everyone for attending the webinar. A recording will be available on the Wagner Law Group website shortly, and please feel free to contact David if you have any questions. Thank you very much.